Hello, everyone. On behalf of Chris Horn and I, Brian Deviney, we'd like to welcome you to this replay of a recent webcast we did entitled The 5 Steps to an Effective Estate Plan. Chris and I moved into our new offices at York Mills last May, and being physically together has really upped our ability to cooperate and develop events like this, but also collaborate on the practice of financial advice. Our speaker today is Jackie Power. She is an Assistant Vice President of Tax and Estate Planning at Mackenzie Investments. She's been there for over 20 years, and she helps financial advisors and investors like you through presentations like this. This presentation, this 30-minute presentation, is not intended as a lecture to go out and get a will or power of attorney tomorrow. Rather, Jackie covers the main aspects of estate planning to get you thinking. Thinking as to whether your unique nuances in your personal and financial life are appropriately articulated in your estate planning documents. Meaning, does your family life and financial life match your will and power of attorney? Chris and I feel privileged to having known our clients for 5, 10, 15 plus years. We know the dynamics of these family lives and financial lives. So if any of these items spark something, please give us a call. We feel we are a great place to brainstorm around the potential issues and opportunities in your estate plan before you step foot in that lawyer's office. So without further ado, here's Jackie Power.
Fantastic. Thanks everyone for taking time out of your day today. I really appreciate it. I'm very excited to be here to talk to all of you about estate planning. This is an area that I find a lot of us put onto the back burner. We think that it's something that we'll do eventually, but it's really important to make sure that we think about this plan sooner rather than later, and that we make sure that all of our everything's in order. Because as we go through the presentation, you'll see that if you don't have a plan in place, then you lose control over how your estate is distributed, and you don't want to find yourself in that sort of a situation. So this is my standard disclaimer. I'm not replacing advice that you might be receiving from lawyers, accountants, any sort of tax professionals. My role here today is to provide you with information that can help you in discussions with those individuals. So first step is to work with an advisor to set realistic goals. So this is working with someone like Brian and Chris, making sure that they understand what you want to accomplish during your retirement. Say for instance that travel is important to you. They need to be aware of that because they're going to have to make sure that you have the funds available to be able to do the sort of traveling that you want to do. The more information that they have, the better off that they can help you and make sure that you're able to achieve your goals. The next area is to consider the tools to fit the situation. So by this, I'm talking about wills and powers of attorney. If you wanted to set up any trusts, and we'll go through the benefits later in the presentation as far as the benefits of trusts in different situations. The majority of my presentation today is going to focus on these 2 points. But I will also be talking about choosing the people to speak for you. So by this, I mean, who is your power of attorney going to be? Both your power of attorney for property as well as personal care. Who do you want as your executor? And I'll help you understand, why you may want to choose one individual over another as we go through that section. Communication is key. Communicating your wishes is extremely important. And throughout the presentation, you'll hear me talk about communication because it's when there isn't communication, that's where the issues begin. And that's where fighting within family members and that sort of thing starts. So the more that people understand what you're trying to achieve as far as your plan is concerned, the better off everyone ends up being. And then I'll talk about keeping your plan up to date. So you might have a very small change within your life that you don't think warrants being discussed with, Chris and Brian and any other individuals that might be helping you with your plan. You need to make sure that everything is communicated. Something very small could actually have a large effect on your overall plan. So when we're looking at working with an advisor, I think a lot of us are looking to minimize tax. And there are different taxes that apply when an individual passes away. So there's income tax that applies, and then there's also probate tax that applies. And for a lot of people are very concerned about probate tax. This is a huge focus for a lot of individuals and something that a lot of individuals are trying to minimize. Now, as we go through, I'll help you understand that when you're making decisions, you don't want to be making decisions strictly based on trying to avoid probate, because you could actually cost yourself a lot more if you're doing that. Now, what's important as far as minimizing, tax is concerned as well, is if you have a spouse, you want your spouse to inherit your assets because your spouse is able to inherit those on a tax deferred basis. So it's only when the second spouse passes away that that tax liability would hit. So that's why generally you would have your spouse inheriting things. You also want to think as you're going through your plan, who do you want your survivors to be? It is completely up to you as to who you want to have benefit from your estate. So we see family members, spouse, children, grandchildren, nieces, nephews, that sort of thing. But it is completely up to you as to who you want to have be a beneficiary of your estate. It could be neighbors, it could be close friends. This is your plan, and there's no one size fits all as far as these plans are concerned. One area that I find falls short a lot of the time in this planning is the business. If you have a business, you want to make sure that you're planning for the future of that business as well. Many people are so focused on running the business that they don't think about succession planning with respect to that. Another area where I find a lot of businesses fall short is if you have a corporation and there's more than one shareholder, generally you want to have a shareholder agreement in place, because what this does is it gives you a roadmap that indicates what happens if someone passes away, what happens if someone loses capacity, or even if there's a dispute between the shareholders. So very important to make sure that you have these shareholder agreements in place. You also want to consider, who do you want the successor of that business to be? You want to be mentoring that individual and making sure that they are up for the role at the time that they're actually required to step into it. Now, another area that you have to consider is guardianship if there happen to be any minor children. Time and time again, I find that this is a reason why people do not put wills together. And I hate to say it, but I fell into that situation, and I know better because I know, like based on what I do for a living, that you need to have a will in place. But my husband and I had thought, after we had our children, about who we wanted the guardian of our minor children to be. So we asked these individuals if they would be the guardians, and they said, of course they would. Before we drew up our wills, we started watching the way that they were raising their children, the way that they were interacting with their children. And we were not happy with what they were doing. And as a result, we decided that then we needed to find someone else. And then that caused a problem in itself because we both wanted different individuals as far as that guardian. So it took us about a year to come to an agreement as to who we were going to have as that guardian. I can tell you that was the most stressful year of our life. Every time the two of us would get into a car alone together, we were terrified that something would happen to us and that the people that we had originally asked would end up getting our children. So I highly recommend that if you know anyone who's holding off on putting a will together because of this reason, or if you are, that you bite the bullet and you just put that will together, because it is so important. Otherwise, you lose control over how your estate is distributed. Now, when we're looking at transferring assets tax efficiently to beneficiaries, life insurance is an excellent tool that you can use as far as that's concerned. What you can do is have a beneficiary designation right on that insurance policy, and that pays out to the beneficiary tax-free. It also gets money into the beneficiary's hands a lot faster than within a settlement of an estate. Even a very simple estate can take 1 to 3 years to settle. And a lot of the time, people need money to be able to run the household and that sort of thing while that estate is being settled. So having life insurance available is really helpful in many situations. Another way that we find the life insurance is being used is as a way of offsetting some of that tax liability that I mentioned that happens when the individual passes away. So because all of our assets are considered to be sold when the second spouse passes, that can be a really substantial tax liability that someone can have within their estate. And as a result, what many people will do is have insurance money that pays out to the estate that can then be used to offset that tax liability. So that's a great tool. As I mentioned, if you have registered accounts, you would want your spouse to be the beneficiary of those registered accounts because they're able to inherit those on a tax deferred basis. And it's only when that second spouse passes away that that tax liability would happen. Another thing that you may want to consider is gifting prior to death. If those assets don't form part of your estate at death, they wouldn't be taxable at death. They also wouldn't be subject to probate tax. Now, with this, I would caution you, you don't want to gift too much and not be able to live the retirement that you want. You worked very hard to have the retirement that you want, and you don't want to put yourself into a situation where you're not able to travel or you're not able to be members of the clubs that you want to be members of because you've gifted too much in an effort to try to save probate or to try to save a bit of a tax liability within your estate. So just be careful as far as that's concerned. Now, joint ownership is something that comes up as a question quite a bit, whether joint ownership makes sense. From a probate standpoint, if an account is joint with right of survivorship, where beneficial ownership has changed, then you're able to avoid probate in that situation. Now, you may be asking yourselves, what does that mean? So you have an account where you're the account holder on that investment account. You decide to put your adult child as an account holder on that account. So in order for beneficial ownership to change, at the time that that adult child is put on, you would have to deem dispose. So you're considered to have sold half of the account. You pay tax on half of the account at the time that that adult child is put on. So now you own half of the account and the adult child owns half of the account. So from a probate standpoint, you've done what you wanted to accomplish, and that child will inherit the account. There will not be any probate tax that will apply. Capital gains tax will still apply on your half of the account, but you've saved the probate tax. Now, there are three things that I want you to be aware of as far as this strategy is concerned. First is now that that adult child owns half of the account, if you want to make any changes on the account, you need that adult child to sign off on those changes. Second issue is that if that adult child has creditors, their creditors can seize their half of the account because it is their asset. Third issue is if that adult child goes through a marriage breakdown, their half of the account is considered family property when that equalization calculation is being done. So this is a situation where I was saying, you know, you could cost yourself more by trying to avoid probate than what that actual probate fee would have been. Now, when we're looking at the registered accounts, as I mentioned, if you can have your spouse inherit those registered accounts, that makes a lot of sense. Now, with a RIF account, you have two options as far as how your spouse can be set up as a beneficiary. So they can be set up as beneficiary, and in that situation, they would inherit the proceeds of the account. They can either choose to put that into their own RIF account, or if they are under 71, they could transfer those assets into an RSP account. So lots of flexibility there. The other option with a RIF account is for your spouse to be the successor annuitant on the account. So if your spouse is set up as successor annuitant, they're inheriting that account as is. So whatever RIF payments are currently coming out of that account, they have to remain as is. So not as much flexibility to have your spouse set up as successor annuitant versus beneficiary. Now, the other account type I wanted to talk about is the Registered Education Savings Plan, or the RESP. So with this account, many people believe that the account belongs to the beneficiary of that account, to the child who's going to use it for post-secondary. It actually belongs to the subscriber of the account. So if you're the sole subscriber on an RESP account, you want to make sure that you have direction in your will as to who you would like the new subscriber on that account to be. Because if you don't have any direction, your executor has every right to collapse that RESP account, distribute the proceeds of that account to the beneficiaries of your estate who may not be the child who was expecting to have that money available to them for post-secondary. So, so that's something to consider as you're putting your will together. Now, the other account type I wanted to talk about is the tax-free savings account. So with the TFSA, this is somewhere where you would want your spouse to be set up as the successor holder, because as successor holder, your spouse inherits the entire account tax-free, and they can put the entire account into their TFSA without the need for TFSA contribution room. If, on the other hand, your spouse were set up as a beneficiary, they would inherit the account tax-free up until date of death, and can put it into their TFSA, that amount up until date of death. But any growth from date of death until the date they receive it would be taxable to them. And if they wanted to put that in their TFSA, they would need TFSA contribution room for that. Now, a question I get a lot is, can someone other than a spouse be successor holder? They cannot. It is only a spouse who can be set up as a successor holder on a TFSA account. So as far as probate is concerned, the value of probate, well, the amount of probate is based on the value of the deceased's estate. So anything that flows through the deceased's estate would be subject to probate. So if you have non-registered accounts, whether they're invested in stocks, bonds, mutual funds, those will flow through your estate and will be subject to probate. Any real estate that you have in Ontario, that will also be subject to probate if you are the only person on title on that real estate. If you have coin collections, art collections, jewelry, automobiles, all of those form part of your estate, and all of those would also be subject to probate. Now, with your registered accounts and your life insurance policies, if you do not have beneficiary designations on those accounts, or if you have the estate as the beneficiary, those will also flow through your estate and will also be subject to probate. So let's look at the flip side. What is not included? If you have a mortgage on your property, the value of the mortgage is subtracted from the value, the fair market value of the property before probate is calculated. With respect to RSPs, RIFs, life insurance policies, if you have beneficiary designations on those will pay out directly to the beneficiaries. As a result, they will not form part of your estate and will not be subject to probate. As I mentioned, if you have accounts that are joint with right of survivorship where beneficial ownership has changed, those will also not be subject to probate. Now, a question I get a lot with respect to joint ownership is with respect to a principal residence. Many people have asked me, when the first spouse passes away, should an adult child be put on title on that principal residence? Generally, I would say no. And the reason for that is because we have a principal residence exemption. So we do not have to pay capital gains tax on our principal residence. If you add an adult child on title on that property and they do not live in that home, you lose half of your principal residence exemption for the years that they are on title. With the way the real estate prices are going up in Ontario, this could definitely cost you a lot more than what that probate calculation would have been. So why don't we look at how much probate is? So the first $50,000 of an estate, no probate is charged in that situation. Anything above $50,000, it's 1.5% that's charged. So if you're looking at a $2 million estate, you're looking at $29,250 in probate. So is it something that we would prefer not to pay? Of course it is, but it's not astronomical in the whole scheme of things. And that's why I was saying, when you're making decisions, make decisions based on what is best for you and not simply trying to avoid probate. So the next section is to consider the tools to fit your situation. So for this, we're talking about wills and trusts and powers of attorney. One thing I did want to bring to your attention as far as all of this is concerned is going back to communication. Communication is key through this whole process. Even if you're looking at things as simple as organ donation. If you have any wishes as far as organ donation is concerned, make sure that you communicate that to your loved ones, because your loved ones are the ones who have final say as far as organ donation is concerned. So you want to make sure that they understand what your wishes are. Another thing to consider are funeral arrangements. So if you have any wishes as far as your funeral is concerned, make sure that you communicate that to your loved ones, to your executor. The reason I'm saying that this is so important is we used to have an estate lawyer who worked with us based out of our Vancouver office. And before he started working with us, he had his own practice. And one of the last clients that he had was an elderly gentleman who had two sons. This individual knew that there were going to be problems with the brothers when he passed away. So he made sure that his sons understood exactly why he had made the choices he had as far as distributing the estate was concerned. One thing he did not think to talk to them about were funeral arrangements. So one of the brothers wanted a very lavish send-off for the dad. The other brother wanted a no-frills funeral. And that was enough to get the brothers fighting. In the end, it was the brother who wanted the no-frills funeral who won out, but this really put a huge stress on the relationship between these brothers. The last time our estate lawyer had spoken with one of the brothers, it was more than 2 years after the dad had passed away, and the brothers still weren't speaking. So it shows you that, you know, that individual had done everything he thought in his power to make sure that there wouldn't be issues between the brothers. But this small lack of communication ended up causing some issues. So the will really is the cornerstone of every estate plan. So it's in your will that you're going to indicate who your beneficiaries are, who your executor is. If you are philanthropic and you want your executor to be able to make charitable bequests on your behalf, you need to make sure that that's included in your will. If it is not, your executor does not have the power to make charitable donations on your behalf. Now, testamentary trusts can also be really beneficial within an estate. These can help delay distribution of assets, but it also allows you to control assets. So I'll give you an example from my personal standpoint. So as I mentioned, my husband and I have 2 minor children. In the event that the 2 of us pass away, we have trusts that are set up for the children. So essentially they get X amount of dollars at 25, another chunk at 30, and the balance at 35. If they want to pull money out to go to post-secondary, they have the ability to do that. If they want to pull money out to put a down payment on a house, there's a certain amount that they can pull out for that as well. So we've been, you know, not a lot of parameters that we've put on the trust. I have a very good friend who has 3 daughters. Her will is about 45 pages long because she has written every possible reason that the girls can get money out of the trust. So it just shows that you can be as controlling as you want, or just more laissez-faire. So it really is very flexible. Now, trusts don't only work for minors. If there's a disabled family member, trusts work really well in that situation. If there is somebody who has addiction issues or is a spendthrift, you can set up trusts for those individuals as well as a way of protecting them from themselves. Now, in the event that you don't have a will, or if your executor cannot find your will, you're considered to die intestate. So before I got into this role, I just assumed if something happened to me that my husband would inherit my estate, but that's actually not the case. So my husband would get the first $200,000 of the estate, but after that, my minor children would get 2/3 of the estate, and my husband the remaining 1/3. My husband has no say whatsoever in how the children's assets are managed. And as soon as the children turn 18, they would receive full access to that inheritance. In my experience, an 18-year-old generally does not have the ability to be able to manage a large sum of money. And a lot of situations have proven that these children just end up blowing through that inheritance. So in an effort to be able to protect them from themselves, you want to make sure that you have a will, so that you're the one who dictates, you know, how those assets are distributed. If you want to set up any trusts, it gives you a lot more flexibility. Now, where I find intestacy falls short in Ontario is with respect to a common law spouse. So a common law spouse in Ontario is considered a spouse in pretty much every area except intestacy. So if you have a common law spouse or you know someone who does, it's even more important for those individuals to have a will, because otherwise the common law spouse is not included in this calculation that's happening as far as intestacy is concerned. So the next area I wanted to talk about is choosing the people to speak for you. So these are your powers of attorney and your executors. As far as powers of attorney are concerned, we have two powers of attorney. We have a power of attorney for property and a power of attorney for personal care. So your power of attorney for property manages all of your investments, all of your property needs. This individual can do everything that you can do, except they cannot write a will and they cannot change beneficiary designations, but they can buy and sell investments, they can buy and sell property. So it's really important for you to make sure that you're choosing the right individual, because these individuals do have a lot of power, if you will. The other type of power of attorney is a power of attorney for personal care. So this is the individual who would make decisions as far as your personal care is concerned. Now, I've had many people approach me and tell me that they do not need a power of attorney for personal care because their husband was recently hospitalized and the doctors took direction from them without asking to see for the power of attorney for personal care. I hear this time and time again, but technically the hospital should be asking to see a copy of that power of attorney for personal care. And you don't want to find yourself in a situation where someone is asking for that and you do not have that. Because then you need to go to court, you need to make a case for why you should be that power of attorney. And it just really slows down the process. Now, what I'm finding is a lot of lawyers, when you go in to have your will drawn up, that they are prompting you and asking you to have those powers of attorney drawn up at the same time. Now, the other person who would speak for you is your executor. So when you're looking at choosing an executor, if you have 5 children, I highly recommend not having all 5 children as executors, because everybody has to agree, everybody has to sign off on everything, and it can really slow down the process. Another thing to consider is if 2 individuals do not get along, don't have them as co-executors. I was approached by a woman after I did one of these presentations, and she said to me, my sister and I are the executor for my mom's estate. And I said, oh, that makes sense. You know, that's very common. She said, oh, no. My sister and I don't get along. And my mom thought this was a great way to bring the 2 of us closer together. As you can imagine, there was nothing further from the truth. It took a ridiculously long time to settle that estate because the 2 sisters just couldn't agree on anything. So when you're thinking about an executor, proximity is something to consider. So if you can find someone in the same city or town as you, that's ideal. The same province is helpful, but the same country is a bit of a necessity. And the reason why I say that, it's not a legal requirement to have a Canadian resident as your executor, but if you have a non-resident as your executor, that individual needs to be bonded. So essentially that's additional insurance that the estate needs to get on that individual for them to be able to settle your estate. The larger the estate, the more expensive that bond would be. So that's why if it's at all possible, you want to try to find somebody who's local, or at least in Canada. Now, you may think about your group of friends and family and feel that there's no one there that would be up for the role of being your executor. In that situation, you may want to consider going the route of a corporate executor. This is becoming more and more popular just due to the complexity of some of these estates. And a lot of people no longer want to put that responsibility onto a friend or a family member, and they're going the corporate route instead. Now, the next area is to communicate your wishes. So the reason why communication is key is because without communication, that's when the legal battles can start. So I'm going to give you just, again, an example as far as my situation is concerned, where I'm hoping that communication is going to stop some problems. So essentially, my brother and I are the sole beneficiaries of my mom's estate. I'm my mother's executor. My brother is a restaurateur, and several years ago, he borrowed a substantial amount of money from my mom to open up a restaurant, and then he just never paid her back. So essentially what she did is she changed her will to say that I get X amount of dollars off the top, and then after that, everything is split evenly between my brother and I. Now, my mom and I had to have a conversation with my brother about this and let him know that this was the reason why this was, set up the way that it was. And because my mom is healthy right now, no issues whatsoever, knock on wood, he said, of course, that totally makes sense. I wouldn't have it any other way. I know my brother. We are ridiculously close to my mom. When she passes away, it's not going to be a good scene and emotions are going to be heightened. I know that if we had not had that conversation with him, he would have said to me, what did you do to mom as her executor to get her to give you that extra money? Whereas when we had the conversation where everybody was level-headed, he understood perfectly why it was happening. And, you know, there shouldn't be any issues at the time that my mom passes. So that's just one example that shows you, you know, how important communication is, and why you want to make sure that everybody understands what your wishes are. Am I suggesting that you tell people exactly what they're inheriting? Not at all. They should just have a general understanding as to why you've made some of the decisions that you've made, especially if distributions are not fully equal. Last point I wanted to talk about is just keeping your plan up to date. So anytime that you have a change in your situation, no matter how small you think that change may be, it is really important to make sure that Brian and Chris, and also any lawyers or accountants that you might have working with you, are aware of what these changes are. Because some small changes can have a ripple effect and can really affect your overall plan. So it's really important for everybody to understand what's changing within your situation so that they can tweak your plan if there are any changes that are necessary. So thank you so much for your time today. These are the points that I wanted to cover, and I would be delighted to take questions if you have them.
So thank you so much for attending. I hope we got the gears going to think about things. So have a great day, everybody, and a great summer. We'll talk to you all soon.